Good morning, ladies and gentlemen. It is a Saturday morning, noon time for the East Coasters, brunch time for us Central Time people. And it's another Saturday, and that means it is another week in court review with Lone Wolf Oozle. I'm here with a smorgasbord of absolute insanity from court standards, of course. We're going to start today off with a follow-up from earlier this week when we saw a dad who was pretty upset with Judge Stevens sending his son to jail. We're going to catch up on that story, and then we're going to move on to Judge McNally, where we're going to see Judge Dad in full effect. Then we got a fairly new judge for Kansas, but in any case, it all starts right now.
Zane Buring, please, done. That you, sir?
Yes, sir.
Okay, what's your address? Is it still 365?
No, I had moved to Austin.
Everybody's moved. What is it now? East William Cannon.
Austin, Texas, yes, sir. East William County.
All right, now, let's get to
Thank you.
the meat, the guts of this one. You're charged with what's called engaging in organized criminal activity, which in summary, you and others collaborated in, according to the grand jury, in carrying on a criminal activity which involved illegal possession of a controlled substance and possession of dangerous drugs and illegal possession of marijuana. You understand what you're charged with? And this, the way this has been indicted, this is a first-degree felony if convicted. You're facing life in prison if convicted. Do you understand?
Yes, sir.
What happened was y'all had a large-scale drug operation going on Homer Drive in Beaumont.
Another big bust in Beaumont. BPD officers found this. It's marijuana, suspected mushrooms, many other drugs, and guns while searching a home on Homer Drive. The search happened Tuesday, and police say charges are pending there as well.
And people convicted of such a thing we're talking about pounds of drugs. They end up paying a steep price. All right.
For roughly 4 weeks. It's a brand new case. Yeah, I just met this morning.
You can hire somebody anytime you wish. The taxpayers would love that. Rather than paying for your mess, we would rather have you earn it and pay for messes. But until then, fill that out. Zane Buren, you got drugs in your system. You got you tested positive for tetrahydrocannabinol marijuana. Your bond is revoked. What is his bond?
30,000, Judge.
It is revoked. It is now doubled to $30,000. Yeah, you can blame yourself, not anybody else. You got to have I'm going to speak and you be quiet. Thank you. This isn't a debate. The test shows you've got drugs in your system. All right. And stand by. Yeah. You shouldn't be surprised. I mean, you're in organized criminal activity of making drugs. Anyway, your bond is now $30,000. Plus, you have to have a drug patch as a condition of bonds. So if you post a bond, once any drug gets into your system, I'll know about it. And then you won't have a bond the next time. It's this one out. Mr. Dusler, you're his attorney?
Yes.
All right. He's going to be taken into custody. What's the next event?
An announcement, Judge.
An announcement in 4 weeks. That is all. And Mr. Buring on this date has filled out an indigent form, and Mr. Dusler will continue to represent him.
Your Honor, if I could address that for you first, I just do something.
I don't know, who are you?
I'm the father of one of the defendants who got already locked up, Zane Bury.
Okay, who is his attorney?
He has a point of warning, but I was not, actually, that's what I was gonna speak to. I was gonna try to He got his bond revoked by you, so you know, had it 30 year now, sir.
Oh, today?
Yes, sir.
Okay.
And, well, sir, he was only arrested March 16th. And he, in school, he's working, he has not been using, he hasn't had enough time for the THC to get out of the system. And his attorney was just a point of, he should have told you that. But he will, sir, he wasn't even picked up, he didn't even have a clue he had a warrant. But he has not been using, sir. I'm his father, I'm been watching every single step of the way, making sure he's reporting, making sure he's doing what he's supposed to do. He's enrolled in school and he has a job at a recording studio. He is.
Yeah, that's right. I remember hearing about that.
Yes, sir. He is all the way out of trouble, Your Honor. He has not been using.
The scientific test proves otherwise.
Well,
It's not a debate.
To rest.
I'm sorry, it's not a debate. If he has drugs in his system when he's tested, that's all we know for sure, because you don't have any method of telling when that went to, you're gonna speak over me? You don't have any method of telling when that might happen. You don't know. You don't know. But when they're tested in the courtroom, when they test positive, sorry, they shouldn't have been ever using drugs in the first place. But when it tests positive, there is no way you can say that didn't have anything to do with recent use, misuse, not you. So you can, all right. You need to tell your attorney, the court's orders are what they are. I'm not changing them because of your opinion. Who is the attorney on the case? Who? Don Dusler. Is he around?
I didn't understand why he didn't say that to you in the beginning when you reported. He didn't argue anything and I didn't understand that.
You need to call him and talk to him. Don, what's his
He
phone
walked
number?
down on me, sir. I'm
gonna give you his phone. I'm gonna give you his phone number. Here, come on out.
He told me he didn't care and that I get to go do something. We tried to speak to him 3 weeks since he was appointed to him. He would not answer his phone. He would not return calls. He would not return messages.
All right.
Not
What's
from anyone,
what's the
sir.
defendant's name? Again, your son's name?
Zane Beering.
Okay, I'm gonna set that for a hearing tomorrow morning.
Okay, we live in Austin, Texas. I got
I'm
up at
sorry.
4 a.m. to be here.
Yeah,
We were gonna
see, he's gone. What I wanted to do is set it for tomorrow, have Mr. Dusler in here explain why he's acting that way. If that's the way he's acting now, I'm hearing your version. I want to hear him too.
Yes, sir.
But he's supposed to handle, all the defendants are supposed to be represented by competent, vigorous representation.
And he told me outside he didn't care, sir. And that's where his words.
Well, I'd like to, yeah, I need to,
Is
to
there
talk
talk
to him
was
about
standing there when I was trying to talk to him?
I didn't hear anything.
Oh, he would, he told me he didn't hear.
Yeah.
He was saying he was outside.
well, I mean, don't call witnesses if you
Sorry,
don't know what they're
no,
saying.
sir, I'm sorry. I just thought, no, he was standing there. I apologize. But Your Honor, I can attest to my son has been staying out of trouble.
Okay, but
I-
the scientific test proves otherwise. We've been doing this 19 years, sir. and
It's been less than 40 days, sir, since he was arrested. And I promise you, sir, he's been doing everything to stay out of the way. Enrolled in school, in
You're
college.
saying that the marijuana has been in his system for 40 days?
Sir, he's.
Is that what you're saying?
Yes, sir. I would like
Sorry,
I would-
it's not gonna work.
Sir,
It doesn't. That's not
marijuana
the way
can
it
last up
works.
to hair and hair follicles 90 days, up to 60 days in your urine if you're a chronic user.
Anything else?
No, sir.
Okay. We're gonna give you, Mr. Dusler's number. I want to know if he's refusing. There's a posted note right there. If he is not, if he does not answer phone calls in regards to immediate family members who are trying to
Yes.
get information for their client, that would be inappropriate. And I'll have,
Yes, sir. I'm sorry.
and then he's appointed at the court's discretion. And if lawyers are not treating clients and relatives of clients, especially those who are in custody appropriately and professionally, then I'll deal with it firmly.
Your Honor.
And that I don't put up with that. And I don't generally get complaints.
And I
But
would,
when it does, when we do, we get to we address them. You have a right to find out as much information as we can about your
For 3
child.
weeks, Your Honor, but Your Honor, I promise you, my son, I wouldn't be standing here if it wasn't for the fact that he was doing so well in life. I would not be standing here for him. Okay,
Yeah.
and
Well, look, just at the end of the day, not to say that you're don't act, don't act naive. But let me just tell you, when people use drugs, I've only been doing this for 40 years, involved as a defense attorney,
Yeah.
a prosecutor, a judge now for 19 years.
Yes, sir.
When it comes to drugs, people are rarely forthright
Yes, sir.
because it's something they know is wrong and they hide it, and it gets the best of them, and they lose their abilities to really think rationally because they become the drug overpowers them, and it's always been that way.
Always, yes, sir.
And
As long as
I see it over and over again.
brother
And
died of
the
drug
family
overdose.
members are the last, they're never going to do things in front of their family or let their family know because they know it's wrong. They're ashamed of it, but they're stuck. And I'm thinking, when we deal with this, we have a 92% success rate in our probation, especially drug cases.
Yes, sir.
The average is 75% in the country.
Yes.
We have a 92 because we deal with things pretty aggressively on getting help, especially with drugs.
Yes, sir.
But
I-
I know what you're saying,
He has,
but
he
I
doesn't
know,
use
I
any
don't,
other drugs.
but I know what happens over and over
Yes,
again
sir.
for 40 years, sir.
Yes, sir.
40 years.
I have no
It's-
doubt in my
The
mind.
parents come up here and they're shocked and ashamed and they're trying to defend their child, but he's a grown up
Yes, sir.
and you don't see him all the time.
We,
And you don't see him all the time, and they're not going to use drugs in front of you. They're
No,
not going
sir,
to want to
I do.
embarrass.
Yes, sir. I wouldn't, I understand what you're saying. Yes, sir.
But
Again,
and
he
the
doesn't
scientific
use-
test is what we use, and that is
Your Honor, if
is,
you were
uh,
to give him a
proven.
chance, if you were to give him a chance, I can guarantee you, he comes back in for 30 days, he will not have anything in his
it's in the
system.
debate.
That would give
I don't
plenty
deal
of time
with-
for his system to be clean of marijuana.
I can't deal with, I'm not going to deal with you on that. He tested positive, and that's what we test for. Now, his lawyer needs to get in the game to get him up here so we can resolve this case one way or the other.
So that's when I had asked him outside. I asked him if he would come in and try to talk to you. He goes, no, this isn't Austin. And I said, sir, you're here to represent my son. He said,
That's,
do you live in Austin? And he brought up Austin again. I said, sir, I lived here as a child. I know what.
I understand, and he
And then
shouldn't.
he walked off on me. And I
Well-
said, sir, can you please go let them know he hasn't been out?
Are you-
home? And
okay.
he's got school in the morning and work tomorrow.
I'm sorry. I can get him back in the morning and talk to the attorney and have him explain, but you're not going to be here. And have him explain what you have told me, and without you being here, it's not going to be much of a debate.
Yes, sir.
But I can bring your son back and ask or direct him, since I appointed him
That
as
would
the
be amazing,
attorney,
sir.
direct him to aggressively deal with this case and also be forthright with family members, close family members, so they are not in the dark on the way he's going to represent your son.
It's just for marijuana, and that stuff binds to the
No.
fats. It's not like it's out of your system in 72 days. If you do the research, it binds to the fat cells in your
Thank
system.
you.
30 to 60
I'm familiar
days.
with it,
Yes,
sir.
Up to 90 in the hair.
But too often marijuana is used
Yes,
as a
sir.
carrier with other methods. And
He just had,
also you don't know what's in how marijuana, some marijuana is stronger than others, and it just works that way and works differently. And that's why when you sniff it, if you smell it, you run like the wind,
Mhm.
especially if you're on bond. Yes, Don.
Yes. Come on after guys. Thank you very much. No, I won't. It was an add-on in shown there.
It's not even shown.
No, it was not. Maybe
What are we doing?
he tested positive yesterday and you wanted him brought back today. Basically, he's asking for some more time, but once he gets out of jail to our attorney, so 4 or 5 week reset.
I need his.
Name bearing, but I know you're gonna get a test daily until he tests positive.
The test negative.
Negative.
The object is not to use drugs and stay in jail. It's to stop using drugs. You tested positive yesterday for THC. Did you want to say something?
Yes, sir.
Go ahead.
I had just got arrested a month ago, so even if I had stopped smoking weed then, I would have not been clean yesterday when I came in. I smoke copious amounts of marijuana, so if I smoke 2 ounces, it's not gonna come out of my system in 30 days, you know? So I came here only because it wasn't that I'm not trying to get clean. I am trying to get clean. I'm trying to do the right thing. So it's not me being in jail is gonna help me do the right thing, but I can guarantee that next time I do come to court, I will be clean. I will not be dirty. I will be clean. I will be on top of my game. Everything you need me to have being done, I get it done.
How old are you?
I'm 29, sir.
You think it's about time you grew up and matured and
I'm
became
trying
an
to.
adult, or are you going to stay childish the rest of your life?
Grow up, so I'm trying to get
Really?
together.
How long have you been using drugs?
I mean, I've probably been smoking weed. I don't use drugs, I only smoke weed, sir. But since I was like 14 years old.
14.
Yes,
And you're
sir.
how old right now? 90. You were born in 95, so you're 30 years old.
29.
You're going on 30 in
Yes, sir.
October.
Yes, sir.
No. Okay. Well, how many? Each time you use drugs illegally, it's a crime. It's a foolish decision, and it's a wrong decision. How many of those wrong decisions do you think you've made?
I've made a lot, sir.
Thousands?
You did a lot, sir. I can agree to that.
Yeah. Okay. Well, it's never too late to mature,
Yes, sir.
but talking about it doesn't do it.
That's what I'm trying.
You gotta
I'm trying to show you.
walk
I can.
the walk. You know what I mean?
Yes, sir.
Everybody says, just let me out of the mouse trap. I'll never eat cheese again. But there are a lot of cheese eaters,
Yes, sir.
like a mouse. Just let me out. I'll never eat cheese again. But that's the nature of their beast, of the beast. They eat cheese.
Right.
Similarly, people get attached to drug usage and they will say and do anything to get out of confinement.
No, that's not right here, sir. I have school that I'm.
You can say no all day long. Don't make me sound foolish. I
I'm saying
know.
I'm trying to go.
Hold on. How long have you been using drugs?
Since I was 14.
Half of your life.
Correct.
You don't think that's a consistent wrong choice lifestyle?
Yes, sir.
Okay. Well, anyway, what was your bond? We revoked it. Yes.
It was, I believe, 15,000.
Yes, sir.
Well, he's not going anywhere testing positive. We're gonna have to see. What's in his
If he
system?
would reinstate his original bond as soon as he tested.
I don't think so.
Okay.
No, I mean, it's gonna be doubled and they'll have to have a drug, not all of them, but you're gonna sit over there and we'll test you and see if you're testing positive or not, but until you test negative, I'm not letting you amble out of here. You understand? Sit over there.
You understand?
Thanks.
I just have school I'm trying to attend. I mean,
You can talk about it all day long. You gotta do it, sir. What else?
It's all, I was gonna reset him. He'll still test positive today.
Also,
Reset him for an announcement. Maybe his family can hire an attorney.
okay. Jacali Palmer.
Judge, if I could speak to the prosecutor, Mr. Carter, about that. He's like to withhold that for a little while.
And Dalen Parkerson.
Dalen, Parkerson, Judge, I'd like to have a reset on that. There's some additional investigation.
How much time do you need? 4 weeks?
4 weeks.
That's all? Okay. That's reset. Darius Smith. Darius, get him a sentence. Darius Smith.
Darius Smith would also like his case, set for trial, I believe. Your Honor.
Who goes to trial for unlawful possession of a firearm by a fellow?
I'm not trying to go to trial, sir. I just know Mr. Rose is a busy man, and I was just trying to get the case resolved.
Oh, you were.
Well,
He says he.
because
I'm not offering information.
schools and all parts.
What's the offer on it? What's the offer on it?
The offer on it is, 4 years TDC.
Hold on, but I'm sorry, y'all are going a little fast. So is Mr. Palmer going over there?
Yeah.
Okay. And then Mr. Parkinson's being reset.
Right.
Okay, thank you, sorry.
Yes, I just.
It's not highlighted, that's fine.
Zane, you're still testing positive.
It's not.
You're not getting out until that changes. So you're taking it into custody.
Get back there.
Say is he blind with fucking be back.
Again, Darius Smith
Yes, sir.
had this conviction on June 7th out of Ellis County. So every time, so you commit a third degree felony each time you're unlawfully possessing a firearm.
That probably, hold on, let me share the locks.
Yes, please.
Yeah.
What other
and then-
convictions do you have?
I have a
Yeah.
felony marijuana.
That the one in 17 from Ellis County, right?
Yes, sir.
What else? That's it.
What's your name? Please raise your right hand and swear over her. And the truth and the truth and the truth shall be God. Need you to each of your right hand. Okay, please sit down.
There's a firearm underneath your seat, the driver's seat.
Yes, sir.
And what's your defense on this?
I had forgot it was there that morning.
That ain't, that's so what?
I understand, but I had took it for like.
That's an extended mag style where it's got 30 rounds, Judge.
See, you're not eligible for probation. You're not eligible even in front of a jury or conviction. Prior felony conviction. Because I don't know if you understand that or not, so.
2.5 right now in school. I was just.
So what?
in school.
Yeah, you got like, just like me.
Yeah.
What would I lose
Yeah.
if I commit a crime? A lot more than you. That's why
Yes, sir.
I don't commit crimes, but
I understand.
um,
So I had got there from my home.
it doesn't matter.
I don't know.
It's illegal possession. I mean, it's
They was trying to keep.
the lower, the lowest is 2. They can do 2. Yes. How much time does he have credit?
Probably not much.
2 days.
Hmm?
2 days.
Yeah.
Yeah. In summary, this indictment alleges that on or about May 18th, 2024 in Jefferson County, Texas, you committed the third degree felony of unlawful possession of a firearm by a previous convicted felon. Do you understand what you were charged with? If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you will be pleading guilty. Whatever sentence shall not exceed a cap of 4 years in prison. We'll order a pre-sentence report and come back after that is done, and then everybody gets to sound in, and then the court makes its decision.
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
I think you're looking at no less than 2, no more than 4 years confinement. You're looking at deferred or unadjudicated probation, and also regular probation can be assessed. So those are 3 options. I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
Yes.
State's Exhibit 1 tendered into evidence.
Objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this the state, so help you God. Is that a true and correct?
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. And the court makes findings in support of State's Exhibit 1, and those findings are in accordance with the recitations in State's Exhibit 1, made a part of the record for all purposes. Pre-sentence report will be ordered. We'll be returning back, and you'll get a resetting. Everybody will come back and sound in, and then the court will make its decision then. And please get a resetting from this lady. What is it, about 4 weeks?
I did June 24th.
Well, ladies and gentlemen, that does it with Stevens. We're moving to Judge McNally, who has some very frustrating situations to deal with, and it starts right now.
Emerson, Amanda Christine Emerson, 25B1482138A, B 25B1478852, and 24B1468880. Ms. Emerson, your name?
Amanda Christine.
Then I've also got 24B146354. 24B146879, 25B147836. I'm told she had a 0.17 on the PBT. Does she want to contest that? I don't know what I'm going to do with you. I don't know what I'm going to do with you. I have no more answers on you. What are you doing to yourself? What kind of drugs?
Just alcohol.
Just alcohol. You have a 0.17 and you've been in here for 2 hours, right? When did you stop drinking?
Around 2.
My Lord, you were up around the 3:0. Do you realize that? Well, I don't know. 0125, 7 hours. That's another 10. Closer to 3:0, 2728. Your name?
Caitlin Foley Carter, Nebraska Township.
I don't have a bond condition that she violated. Because these were trespass charges, there was no evidence that at the time that I arraigned her, that she didn't that she used alcohol or didn't. So I'm gonna go ahead. You guys asked me to adjourn these trials. There's no way I can go on now. But I don't have a bond violation. So all I can tell you is you can take her to Judge Hessen and you can explain. I would have been happy to do, but I didn't have it as a bond violation. I didn't set that as a bond. So we'll set all these, Lisa, for next week, Monday. Apparently they're up for trial, but she needs to go in front of Judge Hessen on the bond violation. I don't think it's fair for me to be the one to do that when I didn't conduct that hearing, when I didn't have that as a condition. But it's 0.177 he wrote down here, okay? That's it. Good luck. Go down in front of Judge Hessen. I'm really worried about you. And the thing is, I can't say I haven't tried. Good luck. Let's do Alger Lucky. I know you guys are busy back there and I haven't been able to get you in here. Alger Lucky. Alger Ivory Pierre Lucky, 22B1397938.
Good morning, Your Honor. Kimberly Bell, P44711. I'm appearing in the house on behalf of Mr. Lucky today.
Your name, sir? Are you here on this?
I am here on Inch, but I can go.
I need you to pull this file. All right, so defendant hasn't been here.
Yes, Your Honor.
We have multiple counts. He has 2 prior technical violations. He absconded. I have 6 counts. How's he going to proceed on these?
Your Honor, as I had indicated to you off the record, I was trying to get some more information as to the status of this file.
Well, the status is that he's blown us off for 3 years. That's the status. I sentenced him May the 12th of 22. I don't know what else to tell you.
Well, let me
You can,
respond.
no.
Okay.
Hang on. You can look at the probation violations. He's got 6 of them. They think he didn't attend his probation visit on October 13, that he didn't attend the court work program on October 5 of 22, that he didn't provide proof of completing 4 hours community service by October 10 of 22. He didn't provide verification of attending and completing outpatient treatment. That he failed to refrain from consuming alcohol and controlled substance, testing positive for marijuana and alcohol back at a chemical test back on September 13 of 22. I don't know what else to tell you. I mean, you can look at the file. He pled to impaired.
Your Honor, may I address you now?
No, you look at the file. I can only do this in one way. I don't do cops, please.
Okay.
He's got a big problem with me.
Okay.
He's blown off the court for 3 years, and I don't appreciate it. So I know he was running the Pentagon. I don't know what to tell you. Seriously, I don't want to hear these excuses. He knows that I know if I told him I'd give him $5,000, he'd have been here 3 years ago.
Give me a chance to.
Yeah, take your time, but I don't get it. I just don't get some of these guys. I really don't. They just, guys and gals, think they don't have to show up for 3 years and then come in and pretend like it didn't happen.
He's not a bad.
Oh, I'm sure he's not. None of them are. Anybody who ignores a court for 3 years is about as respectful as, that's the way I feel about it. You can come back and prove to me I've been thinking wrong for 60 years. Alger Ivory Pierre Lucky, 22B1397938. I don't think I have any more of yours, do I, Mr. Crawford?
Yeah, you got one more.
Okay, go ahead. Go deal with them, and I'm going to take this one and Mr. Inch.
Thank you.
All right, I need Beth Wiles.
For the record again, Kimberly Bell, P447111. I appear on behalf of Mr. Lucky.
Good morning again. Your name, sir? All right, so have you had a chance to review this file?
I did.
What is he going to do? Is he going to plead, or does he want a hearing on these 6 counts?
No. He will plead.
So, sir, if you plead guilty here, I want you to understand your probation could be revoked and you could be incarcerated for 93 days. Do you understand that?
Yes.
And did he sign an advice of rights form today?
He did not, Your Honor.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own. You use the subpoena powers of the court to bring in those witnesses. To testify or remain silent. If you remain silent, that silence would not be held against you. Do you understand that?
Yes.
If you plead guilty, you're waiving your right to a contested hearing. You're waiving your right to a hearing of any kind, and you could be incarcerated, as I said. And again, you have 2 priors, technical violations, it says. But given that you have absconded, you could get the maximum. Do you understand that?
Yes.
Any questions before we go on?
Your Honor, best with Judge Hudson.
Okay. Any questions before we go on?
Amazing. He's impressive.
No questions, Your
All
Honor.
right, as the count one that you failed to attend your scheduled visit on October 13 with probation of 22, how do you plead?
Yes.
You failed to attend your probation visit on that date.
Yes.
Count 2 that you failed to attend the court work program on October 5 of 22, how do you plead?
Yes.
You failed to attend on that day.
I showed up, but I had on shorts and I forgot they didn't know where shorts and sent me on.
Count 3 that you failed to provide proof of completing 4 hours of community service by October 10 of 22, how do you plead?
Yes.
Did you fail to do that?
That's community service on my last day. I had 30 service, but I forgot to wear shorts.
You did 3 days.
Community service is different than court work. You would have set up your own community service.
I don't think we were talking about this, I don't think he understands the court work program.
It's not considered community service. It is community service, but it's supervised court work. So I ordered you to do 4 more hours of community service at some point, and I'm just asking you, did you complete the 4 hours of community service by the due date of October the 10th of 22?
He completed 3 days.
No, that's a court work program.
Oh, you're talking about court.
I sanctioned him at one point in August 31 of 22 in order to complete 4 hours of community service by October 10th. So the charge is that he failed to provide proof of completing that by October 10th. So how do you plead to that?
That's community.
Why are you confused?
Yeah, not guilty.
Did you fail to provide proof of completing community service hours that you were due to do?
I had 4 more left. I had 4 more hours left. The day sent me out. That's my last day of community service.
That's the court work program. I don't know how many times I gotta tell you. When we're supervising, when you're showing up at this building, that's the court work program. That's where it's a little bit more stringent. I allowed you to do community service where you could go fold clothes somewhere, the Salvation Army, or do something else by October 10th.
I can't do it.
He did not, that's the core work program. Are you listening to me?
That's where they sent me home from.
But he said that they sent you home from the court work program.
That's not community service.
My bad.
You could have done community service at Salvation Army, St. Vincent de Paul, a church, Habitat for Humanity, an animal shelter. You could have done it wherever you wanted. You could have done it.
Oh, I had it confused. I'm sorry.
Oh, yeah, that's all right.
Yeah.
But so I'm gonna ask you again, did you fail to complete that by October 10 of 22? You didn't do it, right?
Right.
Count 5, that you failed to refrain from consuming alcohol, testing positive on September 13 of 22 for both alcohol, that's on count 5. How do you plead to that?
Guilty.
And count 6, marijuana. How do you plead to that?
Guilty.
Anybody, did you consume alcohol and drugs, marijuana within the 3 days before September 13?
Yeah.
Anybody force you to plead guilty?
No.
Pleas are accepted to those charges. You got 6 counts. I can't wait to hear what the explanation is. I have a feeling I'm not gonna like it because it's gonna be he didn't have a ride or he forgot or.
Your Honor, I would just very much appreciate it if you at least let me explain something.
No, you explain all of it. Take your time, have at it.
First of all, that was in 2022. This is 2025. Mr. Lucky's in a completely different position in terms of where he is with this case. He wants to take care of all of this and meet his responsibilities under this case. Him not showing up, he moved to Ohio.
Did he get permission to leave the state?
I know where to live in Detroit.
I'm just asking you, did you get permission from anybody to leave the state?
You said I can go to work. I work. You said I can.
I didn't say you could live there though, did I?
No, I had no choice.
I said you can leave state for employment, but go ahead. So he violated probation in that aspect too, but go ahead.
Okay, so, he was in Ohio and because this is based on the OWI charge, his license was revoked, so he didn't have transportation up here. Now he does,
How many drunk drivings does he have?
just one.
They didn't revoke him there.
No.
They just,
No, I was trying to get my license when I end up catching I was just paying my tickets off. When I end up catching tickets last time.
okay, go ahead, counsel.
Okay, so anyway, now he has access to transportation with his brother. Secondly, Your Honor, again, he moved to Ohio,
Whereabouts in Ohio?
Toledo.
This was a second drunk driving, right? Or at least he didn't appear, see. He had one in 15.
I thought this was the only one.
Well, maybe he still has that warrant out. Let me double check out of Dearborn. Go ahead, counsel. I'm listening to you.
Okay, so anyway, because he was in Ohio, that prevented him from coming. He didn't have to, well,
Where's he live in Ohio?
this is what I have to offer.
Where's he live in Ohio?
He's living in Toledo.
Come on.
So now through his brother, which he didn't have that transportation before, he has transportation now. He can get to his scheduled appointments. He can get to whatever programs and whatever he has to do. He's also able to pay all of his probation fees. And I would just ask your honor to consider all that. Like I said, he's not the same guy that he was in 2000.
Well, you're not giving me any reason to tell me he's changed, other than the fact that he moved to Ohio and couldn't get here from Toledo, which is
Well,
only
what
4.
has changed, I should say, not necessarily, I can't speak about him, but what has changed is that he has transportation. He has access to some.
Where does he work?
He was working at the Chrysler plant and then got laid off.
When did he get, what Chrysler plant? When did you get laid off?
January.
How long were you working there?
2017.
Did somebody call Beth on this?
I'm not sure if John did judge for that. I'll call her now.
Well, he did say she was in Judge Hesson's. I don't know if she still is. Can you tell by looking out there, Lisa, is she still in Judge Hesson's?
I can't be her courtroom judge.
Okay. All right, go ahead.
So anyway, for all of these reasons, I am asking you to give my client another
No,
chance.
I just don't,
And
I'm telling you the way, to me, there's no stay of the probationary period. He's been gone for 3 years. Really, as far as I'm concerned, I lose jurisdiction after today. I mean, there's nothing I can do when they do this. That's why it's upsetting.
I understand.
He doesn't show up here. We know what happened. He tested positive. He got scared or unconcerned. He didn't do anything. 2 violations within the first 3 months.
But that's exactly what happened here. He does do it. When he moved to Ohio and wasn't making his probation meetings, he felt that he was already in violation.
Well, yeah.
And I know the thing to do, or what the thing you should have done, was to call someone to tell them what his situation was. But we deal with real people. And,
Do you have kids? You married?
3 kids. That was an old accident.
Where were your kids at?
At school right now.
No. Where were they in 22, 23?
22 was all together. We was all living together after the accident.
Slow down.
Yeah.
How old are your kids?
I got a 19-year-old, a 16-year-old, and a 12-year-old.
Did they all move to Toledo with you?
No.
They stayed in Detroit.
Yes. Me and my lady split up after the accident in one car. It really.
he had an accident, sure.
The thing, that's what I'm talking about. It really messed up my whole life. I had the phone, my old number with the all your contacts in it. She broke the phone. I couldn't get in the iCloud.
Just to put some context to this, on this OWI charge, it was a truck that hit him. And it kind of dominoed from there. And that's what he's trying to explain.
How old are you?
40.
You got laid off from Chrysler, Jeep plant in what month? January?
Yeah, yes.
Is that a permanent layoff or is that?
Yeah, because I can take it full time. I had tightened it down, then I got pushed it back to the back. So now I'm on like what's it called? TS or like a TBT. So I might, yeah, so I might, they might call me for the summer, I might.
Oh, you're a temporary employee?
Yeah.
Who do you live with now?
Homegirl,
Pardon?
one of my friends, she my friend, I would say my girlfriend.
Well, that's all right. I don't need to get detailed. I just wondered where you're traveling about. You left your brothers then, right?
Do I leave my brothers?
Yeah.
No, I don't stay with my brother, he just.
I thought you said it did, maybe I misunderstood you. Did you tell me or did you not tell me that you went to live with your brother in Ohio? Did I misunderstand?
In Ohio. I stayed with my uncle in Ohio. When I left my family in 2022, I went to Ohio and stayed out there in Ohio and was going to work.
With who?
out there.
With who?
My homegirl.
Your girlfriend?
I see my girlfriend.
Ms. Wild's your name?
Elizabeth Welch Fisher.
Can you give me any good news on this one?
I think the only bit of good news that I can give to you on Mr. Lucky is he did complete his victims impact panel. Other than that, unfortunately, it's kind of complete abscondment after he had missed his appointment October 13th. And even the 4 hours of community service was part of penalty from a prior violation. He didn't even complete those 4 hours of community service. I wish I had better things to say, but he just basically up and left and we didn't hear from him again.
And like I said, Your Honor, that's because of transportation issue. It's because he should have called, he should have let the station officer know. However, he didn't do that, and he's in this situation now.
I mean, he just ignored us and ignored us here. I'm looking at this. It's like, seriously?
But you know what people do, Your Honor?
Listen,
When they think they're facing penalties in jail, thinking that they're.
I get it. I get it. I just still, yeah, I get it.
I can appreciate transportation issues, but he was reporting by Zoom, Your Honor.
And not only that, he didn't live in Cleveland. He's living in Toledo. I mean, if I'm going to say somebody that I'm going to excuse somebody for not having transportation that lives in Toledo, I've got to pretty much excuse anybody who lives north of, I don't know, north of 12-mile road practice. And then I'm just not prepared to do. He could have gotten here. He knows he could have gotten here.
He didn't have anybody to help him at that time. He's got a brother to help him now. And that was the problem. It was a problem getting here. The problem with having someone bring him here. And he had his brother.
You know, you're on the same page. I mean, I remember a justice writing something about, well, people don't have to get rides. Let's do it on Zoom. All I know, I don't say this very often. All I know is that anybody that comes here in this courthouse, there's only one of three things. They either live here, they drove here to commit the crime, right? Or they got a ride here. That's the only three things anybody could possibly come in front of me. They either here, they drove here, or they got a ride here. So I don't know what's so difficult about asking people that got a ride or drove here to get a ride here to pay the piper. You know what I mean? So I'm trying to be understanding. I'm telling you, I'm not a fan of this. I never have been, and I never will be. I will do the best I can for him. How much do you have here, Lisa, in fees does he owe?
$884.
He will be able to pay that right away, Judge.
Does he have any credit coming other than the
The
one?
only credit I can say is we had scheduled for the work program. He was a no-show a few times. He wore shorts once, but he did complete at least one day on the work program, which was August 3rd. So I would say he's got a day of credit for that, Your Honor.
Doesn't look, it looks like he had a warrant out of someplace in 2015 out of the Dearborn District Row WI. I don't see any disposition on that, either on his traffic record or on the criminal history. I don't know what happened with that.
Your Honor, I can't say this for certain, but I don't believe he was charged. This is because it's my understanding, this is his only charge.
Well, they issued a warrant for him on an OWI at one point, failure to appear in court back in 15.
I do have the screening assessment, obviously done at the time of his plea, Your Honor, 2012 out of 19th, he had failure to appear on drug and license suspended. 2015 out of Dearborn 19th for OWI and drug and license suspended. He also had 2019 out of 34th, but those were for civil infractions of speeding and no.
I'm not gonna take that into account. I was just mentioning that. If there's no evidence of a conviction, there's no evidence of a conviction. Probation is revoked. You're to pay costs of $950 and serve 93 days jail, credit 2, for a total of 91. If you pay costs of $950, I will suspend 72 of the 91, requiring you to only serve 19. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. So you pay that money now, you'll be out in 19 days with credit for time served. No.
I got one last issue, Judge. You're gonna be sick of me. But there was a court date scheduled for May. And he didn't get a notice and I didn't get a notice. I spoke to the clerk, Lisa. I submitted an appearance by internet. She says, no, the court never got an appearance from me. And the notice was sent to Mr. Lucky's former address on Braille in Detroit and not to his current address.
Well, how are we supposed to know?
I don't know. I did my part.
Well,
At least I thought.
but we don't have an appearance in the file until the one you filed on May the 15th.
Exactly, that's what she told me, and I don't know how that happened.
So I don't
Because
know.
I didn't, the appearance I sent in, I didn't send it in to Lisa. I didn't write down who or where
So what are you asking?
Sorry.
I don't know what you're asking me.
Oh, if you would reinstate the bond. And that was.
There was a third-party bond posted, Judge.
Yeah.
And now we have to pay.
I'm not gonna, I'll tell you what, if you want to, if you want to address this when he's out of jail, I don't have a problem. I don't even have a problem with you addressing it by Zoom, but there's too much for me to digest here. When people don't show up, I'm not gonna apologize. I don't like it. And you play.
Can we get the bond? Can we at least apply?
I heard what you said. I understand, but he hasn't shown up for 3 years. I mean, what is this?
Okay.
What bond are you talking about? The one?
Judge, I can explain it. He posted a bond, so I set a court date. He did not appear because we had an old address. She states that she filed an appearance, but I never received it.
Is this a bond that he posted online on or about April 22nd?
Yes.
Yeah.
Yes. So then when I heard from her questioning why she never got a date, she sent me a new appearance and I reset the court date.
I don't have a problem with reinstating the bond, but he's going to have to pay whatever else he paid because that's in the name of the third party poster. So the third party poster can come in here. We'll refund the money to the third party poster.
Okay.
Okay, I'll do that. I can
Thank
see
you.
that at least he did that.
Thank you.
But he's going to have to pay his money today without the bond. And then he'll just have to serve those days that I gave him, which is after he pays the bond 19, or pays the fines and costs 19.
All right.
Stop doing this. Good luck. Have a seat. Thank you. People against. Jeffrey David Inch, 23R513309A. All right, Mr. Gaith, your name?
Good morning, Judge Madison Gaith, up here on behalf of Mr. Inch.
Sir?
Jeffrey Inch.
So he was going to plead, or did he plead?
He pled to
Count one.
Count one, Judge.
So, but then I didn't want to accept the plea until I had you in here. Your name?
Elizabeth Watts, patient, Your Honor.
What's going on with count one, or count two rather, is failure to submit to twice weekly chemical testing on May 24th? I'm asking you, Ms. Wilds, do you want to?
I apologize, Your Honor. Mr. Inch appeared for testing on the 24th. His first sample was dilute. His second sample was dilute. Because he arrived so close to when they closed, he arrived at 9:20. Testing stops at 9:30. Within that span, they did allow him 2 attempts to provide a sample, so there was no time for a third sample. It was a weekend. There is no PM testing, but what all sobriety court defendants are aware of, and I instructed Mr. Inch on this prior, is that if you don't show for testing in the morning or provide a sample that is testable, what Mr. Inch didn't do is he didn't go to the alternative site that evening. On Sunday, he didn't go to the alternative site a morning or evening. He did not test on Monday. He did not test on Tuesday.
All right, so unless there's gonna be a plea here, I'm just gonna swear in and listen to her testimony and listen to whatever you have to say, Mr. Gay. And I'll make a ruling on count 2.
Yeah, I guess let's.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I do, Your Honor.
Go ahead.
Would you like me to repeat, Your Honor?
Yes, please.
Yep. Mr. Inch did show for chemical testing May 24th. His first test and his second test were both dilute. Due to him arriving so close to their end time of 9:30, he arrived at 9:20 a.m. There wasn't time for Mr. Inch to stay for a third sample. It is the weekend. DNA does not offer evening hours, but as instructed in the sobriety court handbook, as well as additional paperwork that Mr. Inch has received, is that if you do not provide a good testable sample, you have to arrive to the alternative site. What Mr. Inch didn't do was follow through with those instructions as well. He did not show that evening, which was a Saturday, at our alternative site. He could have went on Sunday, the next day, again, did not go to the alternative site. He could have appeared back at DNA on Monday or Tuesday, although his color of yellow was not called, colors were called and they were open, and he did not go. His color was called today. It does not appear yet this morning, but again, he does have an opportunity to go this evening between 5 p.m. and 7 p.m. I did not receive any communication from Mr. Inch. I was out of the office last week. Monday was a holiday, but Mr. Inch did not reach out to the probation department in regards to this issue.
Any questions of her, Mr. Gaith?
No questions, Judge.
Does your client wish to testify or remain silent?
Judge, at this point, I'm gonna have him remain silent. I'd like to, with regard to what Ms. Wild said, Judge, my client, according to what he's told me this morning, did not even know that he had a violation until this morning with regard to that test. Now, he told me that he did go to the testing, and the only issue that came up was it came up dilute.
Well, dilute isn't good. They know they're not supposed to drink 14 gallons of water.
Understood, Judge. But in Mr. Inch's defense here, Mr. Inch, he's got other violations, and he's always been truthful with the court with regard to the other violations. Even when they showed up negative through the lab testing, he still admitted when he did something wrong. He admitted he took responsibility for it. And Judge, at this point, I mean, I would believe that he's got no reason to deviate from what he's done.
What did I do when he admitted that he had it in the probation the confirmation test came back negative? Do you remember? Did he tell you what I did?
Well, Judge, you found him, you gave him credit for being honest with the court.
And I dismissed the show cause, right?
Correct.
So even though he admitted something that I felt like clearly established his guilt, there's no question about it. But because he was honest and because we preach honesty in the program, I felt it was inappropriate to penalize somebody who we told you have to be honest to and was honest. And the confirmation test, as it turns out, came back negative. That's why I went ahead and dismissed it. But this is kind of like, how do I say this? I don't want to get too melodramatic here, but what you've had here, it all lines up. He didn't show up, essentially, because he diluted his test. That's what he'd done. He had 2 dilute tests. He could have gone to another site. He didn't do that, even though they're told to. He went to another, he could have gone to another site the next day. He didn't want to go because he diluted the sample for a reason. And then the following day, he still didn't go. And I've been watching Jeffrey here. I like the kid. I like him.
Judge, he's close to graduating. I mean,
I don't
he's
care.
only got-
I don't care. I don't care. I'm finding you guilty as charged.
Oh, can I speak on this?
No, you can't speak unless you want to testify.
I want to speak on this.
Do you want to testify?
I would like to make clear that I was not fully aware that it was, I knew the first test was dilute. The second one, she said, okay, Mr. Rich, you're good. I didn't know that meant it was still dilute. I did not know. I would have gone the second day. I've done that before, prior, a year ago when I diluted. I've been honest the whole time, like you just said.
I don't want to hear it.
I'm just telling you, if I made a mistake, I would tell you. I'm dumb. I've had too much going on at home.
Why were you dilute? Let's talk about why you
Because
do.
I work a physically active job.
No,
I'm trying to drink
no.
water.
What do you tell those guys with regard to how much water they can consume?
No more than 12 ounces.
Now, it's not been 107 degrees with high humidity so far.
It's not, but I'm just
So, yeah. So if we're gonna have dilute samples every time it's 58 degrees out, and that's about what it was last week, or 60, we're gonna have a big problem. You'll never have a valid test because they'll all be dilute because it's gonna get hotter before it gets colder. Look, I warned you. I warned you with all of this. I warned you. You had to know you were on thin ice with me. You were doing so great, and now all of a sudden you're falling. Doesn't do any good to graduate if you're not going to keep up the program. And I mean, just stay sober. It doesn't do any good. I mean, this whole thing about completing programs, what does that have to do? It's like the guy who goes to Harvard, gets a degree, and ends up salting fries at the local fast food restaurant. I mean, it's the same concept. It does not do you any good to graduate from a sobriety court if you're still using. Now, you know what the rules are. You know what the rules are. I want you to get that lady on the phone, but I'm going to give you the benefit of the doubt in the sense that I'm getting that person on the phone on another court date here, Beth. Whoever was tending to Mr. Inch on that day, I want him on Zoom. And I'll tell you what, I'll give you the benefit of the doubt. I'll continue the hearing, but you're either going to testify or you're going to remain silent. You can't have the best of both worlds. You can't say, I'm going to remain silent and then say, wait a second, I want to talk. You want to talk? I'm going to swear you to an oath. Do you want me to swear you to an oath?
I guess I'll just remain silent, Your Honor. I would like to graduate this program.
Hang on.
No, Mr. Inch, just answer the judge's question. Either do you want to
just-
testify?
Not talking.
Well, you can't have the best of both worlds.
Judge, are you?
You don't, wait a minute. I want to make sure Mr. Inch understands this. You have the right to remain silent. There's nothing wrong with you remaining silent. But you can't remain silent and then start telling me your story and expect me to take it into consideration when you're not under oath.
Just don't know what to do. I want to complete this program.
I don't care. Jeff, I want you to listen to me. I'll give you more time to confer with your lawyer. We'll get the woman in here on Zoom. We'll continue the hearing date next week. I'll give you every opportunity to question her. Have your lawyer question her as to whether or not she conveyed to you that the test was fine and you were free to go. We're gonna get her in here. When is a good day when Mr. Gates here, Lisa?
I have to check his schedule because you're off a few days next week.
it's funny because even before people violate, I kind of, and I don't mean this, I've just seen this with you, Jeff. The guy was so proud of, and now you're just screwing around. You act like this is a option to violate probation when you feel like now. Listen.
Can we do June 9th in the afternoon? He's here at 1 p.m.
What day of the week is that?
It's a Monday.
Yeah. Is that good with you, Mr. Gay? You're here?
Yeah, I'm here anyways, Judge.
June 9th at 1 p.m. So I want you to get them. We'll continue the hearing. Okay? That's it. We'll see you next week, Jeff. And I don't know what I'm gonna do now, but I'm really disappointed in you if my mind doesn't change. Good luck.
Well, Judge Dad is disappointed again. It happens almost every week. Sometimes he's not so disappointed. Right now, we're going to go to Kansas, ladies and gentlemen. We're jumping past the 29th and we're going right into the 30th. And we're going to look at Judge Ward. He's not a new judge per se. He's in there every once in a while, but he's one we don't get to see a lot. But it starts right now.
All right, I'm Judge Ward, and this is the first appearance docket for Butler County District Court for May 30th, 2025. I have a list of cases here in front of me, and I'm just going to start. I'm going to start with the in-custody cases. First, Justin Farley.
Yes, sir. Yes, sir.
All right, there you are. Thank you. All right, this is State of Kansas versus Justin Farley. The case number is 2025 CR 244. Mr. Farley is in custody. And the state appears by Mr. Regier. Is that right?
Yes, Your Honor.
Okay. And remind me of your first name?
Jared, Your Honor.
Jared. Okay, Jared Regier. Thank you. Let's see, Mr. Farley. You are charged. Mr. Farley, can you hear me all right?
Yes, sir.
All right, thank you. You are charged in count 1 as follows, that in Butler County, Kansas, on or about April 22nd through May 28th of this year, you did knowingly and without authority disseminate a video, photo, film, or image of another person, Cassandra Davis, 18 or older, who was nude or engaged in sexual activity and under circumstances in which she had a reasonable expectation of privacy and done with the intent to harass, threaten, or intimidate her, and she did not consent to you disseminating her image. That's a charge of breach of privacy, a level 8 person felony. Do you understand that charge?
I understand it, sir. Yes, Your Honor.
I'm not asking if you agree with it, just as
Yes, Your Honor.
that's what you're charged with. All right.
Yes, Your Honor.
Count 2 alleges that in Butler County between March 1 and May 28 of this year, you did then and there unlawfully and knowingly damage, destroy, deface, or impair a house and yard at 15903 Southwest Prairie Creek Road in Rose Hill, in which Cassandra Davis had an interest without her consent, and the damage being a total value of $25,000 or more. That's known as criminal damage to property. It's a level 7 non-person felony. And finally, count 3 alleges that on or between April 1 and May 28th of this year in Butler County, you did unlawfully and recklessly engage in a course of conduct targeted at Cassandra Davis, which would cause a reasonable person to fear for their safety. And you actually placed her in fear. That's known as stalking, a Class A misdemeanor.
Yes,
So
sir.
you're charged with 2 felonies and 1 misdemeanor. So, do you have an attorney?
No, sir. No,
Okay,
Your Honor.
are you applying for court-appointed counsel?
I need to figure that out. I need to figure that out, Your Honor.
Can you afford to hire an attorney?
That's what I need to figure out. I don't know today. I want to plan on let's plan on a court appointed attorney right now.
Okay, all right. you're gonna need to fill out an application of indigency. Have you done that?
No, no, sir.
I'm gonna order that you do that today and get it submitted so it can be reviewed. Does, Mandy, let me ask you this, do the judges appoint counsel before they've reviewed that and then?
I want to get my own attorney. I want to, that's what I'd like, Your Honor.
Yes.
I I'd like to get my own attorney. I can, take care of that. I want to do that.
All right. Okay, well, I will, we'll note here then that you are going to hire your own counsel. Because one or more of the charges against you is a felony, I'm going to put your case on what's known as the felony preliminary hearing control docket. Now, do I just go 1, 2, 3, 4 on these things or assign them all to Judge Satterfield?
Okay, so he's assigned to Judge Crum.
Oh, I see that because that's on the docket sheet. Is that how I'd know that? Okay. All right, this case is assigned to Judge Crum. And his felony control docket, prelim control docket is July 21st at 2:30. Here in the Butler County District Court. Are these personal appearances? Okay. Apparently you have the option of appearing by Zoom or you can appear in person. So these judges, when they do these prelim control dockets, do these defendants have an option of coming into the courthouse or is it all by Zoom? Okay, all right. So your option is to appear here at the courthouse or appear by Zoom. Your hearing date is July 21 at 2:30. I need to set a bond in your case. Mr. Regier, do you have a recommended amount of bond?
Yes, Your Honor. Besides all standard conditions, the state is recommending a cash or surety bond in the amount of $10,000. The state is also recommending as special conditions of that same bond, no contact with the victim, or the property, as well as GPS monitoring. This is the defendant who the state understands has some prior conviction history if the court considers it relevant, misdemeanor criminal restraint and misdemeanor battery. It would appear that pursuant to the affidavit, specifically paragraphs 8, 9, 10, and 13, it is alleged that there was significant damage to the victim's property, estimated at approximately $40,000. It is reported that multiple neighbors identified the defendant as spray painting various expletives in reference to the defendant along the west side of the residence, which were visible from an adjacent property. Paragraph 10 appears to detail efforts by the defendant to use social media to document damage to the property via photographic and video footage, as well as posting photographs and videos of the victim in various states of undress, and the defendant admitting to law enforcement that the social media page used to document these photographs and videos belonged to him, as well as admitting to law enforcement that the defendant did cause the damage to the residence. So for all those reasons, and given the fact that this is a case that involves multiple charges, including at least 2 felonies as previously observed by the court, 10,000 GPS monitoring, no contact with the victim or property, and all center conditions is highly appropriate.
Farley, do you have any comment?
No, Your Honor.
I think a $10,000 cash or surety bond with GPS monitoring is appropriate under the circumstances of this case. The GPS monitor will need to be in place before you're released from custody. You're not to have any contact with the alleged victim in this case or her property, and to abide by other standard conditions of bond and GPS monitoring. You've indicated you're going to hire your own attorney. Your next appearance is July 21 at 2:30 here in Butler County District Court. Is there anything else?
No. How do I understand the 10,000 surety? The 10,000.
That means you have to post $10,000 cash with the clerk of the district court or pay a bondsman.
Or hire a bondsman. Okay. Okay.
Mr. Regier, anything else?
Not from the state, Your Honor.
All right. We're in recess. Thank you. All right. My next case is State of Kansas versus Troy Arnold. Is Mr. Arnold present? There he is. Okay. You need to unmute that. There you go. Are you Mr. Arnold?
Yes, sir.
Okay. The state appears by Mr. Regier. Mr. Arnold is in custody and without counsel. Mr. Arnold, this is your first appearance on a charge that reads as follows, that on or about February 23rd of this year, Troy Arnold did then and there unlawfully and knowingly damage a cell window at the Butler County Jail, in which the county had an interest without their consent, said damage being a value of less than $1,000. So you're charged with criminal damage to property, a Class B non-person misdemeanor. That's the one charge against you. You understand that charge?
Yes, sir.
Okay. It's a misdemeanor. It's assigned to Judge Webster. Do you have an attorney, Mr. Arnold?
I do not.
Can you afford counsel?
No, sir.
How long have you been in custody?
About 30 days.
Okay. Are you employed?
No.
When's the last time you worked?
It's been a little while. It's been about 6 months.
Okay. You need to fill out an affidavit of indigency.
Okay.
And I will appoint Mr. Darren Patterson. Does he do the misdemeanor contract still? Yes. I will appoint Mr. Darren Patterson to represent you. And let's see, I will set your case on the misdemeanor control docket August the 4th at 8 a.m. That's here in Butler County District Court. So your next appearance is August the 4th. I'm not sure what day of the week that is. Is that a Monday? Okay. Monday, August, yeah, it says right there. Monday, August 4th at 8 a.m. That'll be in front of Judge Webster. Mr. Patterson is your court-appointed counsel.
Okay.
I'm going to set your bond, or your bond is already set at $1,000 cash or surety. And were you arrested on this warrant, or is it still active?
I was not arrested. I was already here. I've been here since April 29th. I tried to tell them I had court for you guys, but it wasn't showing in the system.
Yeah, it's been served on you. So your bond is $1,000 cash or professional surety. Your next appearance is August 4th at 8 o'clock. Your attorney is Darren Patterson. Do you have any questions?
Is there no way to OR the bond on that one?
No, there's not.
No. Okay. All right.
All right.
So
We're in recess. Thank you. My next case is State of Kansas versus Dustin Fisher. Are you Mr. Fisher?
Yes, Your Honor.
All right. Very good. Mr. Fisher, you are charged as follows. In count one, you're charged with possession of fentanyl, a level 5 drug felony. That's alleged to have occurred here in Butler County on May 31st of last year, that you did unlawfully possess the drug fentanyl, which is an opiate at that time. That's a level 5 drug felony, count one. Count two is on that same date here in Butler County, you are alleged to have possessed with intent to use a straw to ingest or inhale a controlled substance. That's possession of drug paraphernalia. And that is a Class B misdemeanor. Count three alleges that on that same date here in Butler County, you did then and there unlawfully operate a motor vehicle on a highway of the state without a valid driver's license. That's a Class B misdemeanor. So you're charged with 2 misdemeanors and 1 felony. Do you have an attorney?
I do not, Your Honor. Not to my knowledge. Yeah, I'm due to be out in like 9 days. Probably meet up with one. I mean, if you could appoint me one.
What do you mean you're due to be out in 9 days? What do you mean by that?
I have. I'm down right now on a sanction, a 45-day sanction, and I'm 36 days into my 45-day sanction.
Okay.
So
you're on community corrections in another case?
Currently, yeah, in probation. So.
Okay. All right.
Your
what is your financial situation? Are you employed?
No, I haven't. I do not have a job. I'm currently, incarcerated. So, but I have every intention and plan to get a job when I get out. Be actively looking.
So you want me to consider appointing counsel for you?
I would appreciate that, Your Honor.
Does the jail have the court-appointed counsel forms? The applications?
We do not, Your Honor.
So where do they fill those out?
Your Honor, when I get out, the day after I get out, which would be, I get out on the 8th. The day after I get out, I can go talk to Ryan Smith. He's my probation officer over at, I don't know, is this going to be municipal or district?
No, it's in district court.
Oh, yeah, I'm not 100% sure how to go about that then.
Okay, well, here's what we're gonna do. It sounds to me like you're indigent. I want you to, I don't understand why the jail doesn't have those forms for the inmates to fill out.
We have those here at the courthouse. If he got out, he could just come down to the courthouse and grab one from the clerk's office and fill it out and leave it with them.
Okay, all right.
Your Honor, would you want me to do that like the day I get out?
Yes. Yes. So
Okay.
I'm going to go ahead and based on your current status of indigency, I'm going to appoint Mr. Jim Watts to represent you.
Okay.
This case is assigned to Judge Ricky. I'm going to set this case on his felony preliminary hearing control docket, July 7th at 2:30. That's a Monday.
Okay.
Your next hearing is Monday, July 7th at 2:30 here in Butler County District Court.
Okay.
Mr. Watts will be notified he's been appointed to represent you, but soon as the day you get out of custody, you need to come to the courthouse and fill out an application for court-appointed counsel. You understand that?
Yes, Your Honor.
Okay. Do you understand the charges?
Yes, Your Honor.
Do you have any questions about them?
Not currently. I mean, I have some questions for when I get my attorney.
Right. Right. Okay. So, Mr. Regier, do you have a recommended amount of bond?
Yes, Your Honor. Besides all standard conditions, the state, with special emphasis on no contact with illegal drugs, given the nature of counts 1 and 2 of this case, the state is recommending $7,500 cash or surety, as well as GPS monitoring. As the court has already observed, this is a case that appears to involve at least one alleged felony and multiple alleged drug charges. This is a defendant who the state understands has a history of both convictions and adjudications. At least one prior felony person adjudication and an adjudication for misdemeanor possession of certain hallucinogenics. On the issue of convictions, the state understands this defendant does have prior convictions for misdemeanor possession of certain hallucinogenics, DUI, 3 driving while suspended, and 1 habitual violator conviction. Additionally, this is a defendant who the state understands has a history of failing to appear at least 15 times, most recently in February of 2024. Therefore, the state is respectfully suggesting that GPS monitoring and the $7,500 cash or surety bond is appropriate, as the state does consider this defendant a significant flight risk. I would also tell the court that this is a defendant who appears to have another open Butler County case, Butler County 24 TR 0225. It would appear that previously that matter proceeded to sentencing. More recently, I'm showing an appearance bond in that case for a first appearance hearing on a request for probation revocation that is currently set before the court in approximately 2 weeks' time.
Is that for probation or corrections?
Does he have a hold on him at the jail on a case other than this one?
I don't have that information in front of me at the moment.
As far as I know, I've asked if I had, if I have anything, any holds or anything. They told me all I have is a release date. And does this mean I'll have to post bond to be released on the 8th or?
Yes, it does. I mean, it's a new case. I'm going to set a new bond. And I will set your bond at $7,500 cash or surety. I will require GPS monitoring. Condition of bond is no possession or consumption of drugs or alcohol. Report is directed to Ryan Smith. Come immediately to the courthouse upon your release and fill out an application for court-appointed counsel and appear here July 7th at 2:30 with Mr. Watts on the prelim control docket. Now, if you're still in custody, then you'll be transported in for that hearing. So things are getting a little more complicated for you, Mr. Fisher, because you're picking up more cases.
Yes,
So
Your
if
Honor.
there's nothing further, we'll be in recess. Thank you.
Thank you, Your Honor.
Okay, the next case is State of Kansas versus DeAndre Hadley. There's Mr. Hadley. The case number is 2023 CR 165. Mr. Regier appears for the state. Mr. Hadley appears by Zoom. Let's see here. This case has been pending for quite a while. Looks like the last hearing was on February 14th of 2024. Is that what you're showing, Mr. Regier?
Your Honor, it would appear in my file, there is a journal entry of misdemeanor conviction and sentencing from a February 14th, 2024 date. More recently, I am showing that a request for revocation was filed with the court very recently, and it would appear that an appearance bond has been executed with it in very close proximity to today's date.
Okay, let me look at the file a little closer. Mr. Regier, is it your understanding that this then would be his first appearance on this warrant show cause?
That is what my records would appear to reflect, Your Honor.
Okay. So Mr. Hadley, you were and are on probation with looks like Sarah Wheeler is your supervising officer. Is that your understanding?
Yes, sure.
Okay. She has filed a request asking that your probation be revoked, and a warrant show cause was issued by the court. You were arrested on that warrant and you've posted bond. We'll talk about that in a minute. But let me tell you what she alleges that you have failed to do that would constitute a violation of your probation. Ms. Wheeler alleges that you have failed to report to her as directed, that you have failed to pay all your fines and costs as directed, that you have failed to refrain from using alcohol. In other words, you've used alcohol. That you have failed to get a drug and alcohol evaluation that was ordered by the court. And you have failed to get and keep a job. Those are the conditions of your probation that she asserts you have failed to do. You understand those allegations?
Yes, sir. I start one on Monday.
You start a job?
What?
Okay.
Yeah.
All right. Your attorney in this case was Mr. Jim Watts. Was he convicted of a felony in this case?
Your Honor, the state's information appears to indicate that on March 31st, 2023, multiple felonies were filed pursuant to the same. However, it would appear that in that sentencing journal entry, counts 1, count 2, and count 3 all appear to be listed as misdemeanors.
Okay. Well, even if they were amended to misdemeanors, Mr. Watts stayed hitched as his lawyer. I assume we don't go to Darren at this point, do we? Is it your understanding too that these are all misdemeanor convictions? Okay. All right. So here's what I'm going to do, Mr. Hadley. I'm going to appoint a different lawyer to represent you. His name is Darren Patterson.
Darren Patterson?
Darren Patterson. His office is here in El Dorado, Kansas, right near the courthouse. This case is the case, Judge Crum has this case, and I'm going to set it in front of him on his warrant to show cause docket. And so the hearing will be Friday, July the 25th at 2:30. And you have to show up at the courthouse here in El Dorado. Are you writing this down?
No, ma'am. No, sir. Could you tell me the date again?
Friday, July the 25th. Get yourself a pen and a paper and write it down.
You typed in Friday,
July
July 25th?
25.
July 25.
Friday, July 25th
And I have,
at 2:30. You need to be here.
okay,
And your lawyer, Mr. Patterson, will be here with you.
okay. At what time?
2:30.
2:30.
Are you having a hard time hearing me?
No, I can hear you. I was just making sure I got it.
Did you write it down?
Yeah. Well, I typed it.
Okay, Friday, July 25th at 2:30 here in Butler County District Court. That'll be in front of Judge Crum. And your attorney, Darren Patterson, will be with you. Now, you've posted a bond, 5,000 cash or surety to be here today. And you are present. So I will continue you on this bond to be back in front of Judge Crum on July 25th at 2:30. So I'm going to approve this bond. Do you have any question?
No, sir.
Mr. Regier, anything else?
Your Honor, on the issue of bond, approximately halfway down the first page, it does appear to be specifically initialed that the principal shall report as directed to court at the above location and date and time. The state would be requesting a ruling as to whether or not that means that the defendant is ordered to appear in person for all future proceedings. Based off of the current procedural history of this case, the state would consider that highly appropriate.
Well, I thought I told him he had to appear in person, so I want to make sure you understand you have to appear in person at this hearing on July the 25th. Do you understand that?
Yes, sir.
Not by Zoom, in person.
In person. I got it.
In person. And I'll leave it up to Judge Crum what you do after that. It's his case. If you don't show up, you're going to get arrested. So make sure you're here.
Okay.
All right, we're in recess. Thank you.
Yep.
All righty.
Well, that was Judge Ward. And now, ladies and gentlemen, I bring to you for the last hour or so of the show, 2 days, May 29th and May 30th from Judge Simpson. And it's some good stuff, ladies and gentlemen, and it all starts right now.
Court calls case People versus Stephen Johnston.
Maybe original.
Okay, I'm gonna put a tether on him. Where's Bukovich? He has not been up here for any case I've called of his.
Yes. Sorry. Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Johnston.
Your name, sir?
Stephen Johnston, Your Honor.
Thank you. What are we doing?
We'll be requesting a brief adjournment to pursue some negotiations. He also has some matters in the circuit court that we want to possibly reconcile together.
No objection to the adjournment. I did want to approach regarding a bond concern with Mr. Bukovich and with Ms. Senda, if you could, please.
With Ms. Zenda?
Yes.
Oh, dear God, come on. All right, record should reflect we've had a brief bench conference in this case. What I'm gonna do is I'm gonna move this PCC to 3 o'clock. There's information that's gonna be supplied to defense counsel that could affect the defendant's bond and the conditions on his bond. So I want to make sure we have at least some time to look at that information. So I'll pass this until 3 p.m. Thank you.
Possibly.
Court calls the case People versus Martez Dalton.
Assistant Public Defender Tina Asshole appearing on behalf of Mr. Dalton. Your Honor, but not with him. I did receive information this morning that he contacted Mr. Bowling from our office and that he is on a bus from Detroit and was en route this morning.
No.
I think this happened last time.
Like 3 or 4 weeks in a row of a bus story. No.
I think I might have missed those dates, but it sounds like he appeared eventually.
I can tell you the attorneys in your office to talk to about the bus thing. So where is he right now? Because Cannon was involved with the bus. She's the one that had the picture.
I'm like, why?
Video.
If I would have known, I would have submitted a Zoom.
So what?
In suits.
I know. I had no idea of all this. Or
Who's innocent? No, Apple. No. So where he's coming from a bus from Detroit? That's where it always starts. So what do you want me to do?
If the court would be so gracious to pass this matter.
Okay, so the first one I passed was at 9 o'clock. We called him what? At 3 by the time he got here. The other one didn't get called till late afternoon. You have no idea where do you really have any idea if he's on the bus?
My understanding is he's talked to Mr. Bowling this morning and was on a bus en route.
So Bowling's the one that's telling us bus.
Yes, I have not had direct. I have no reason not.
All right, then I need video. I'll pass it.
Maybe I can get a photo.
Video other than like out the window seeing trees go by. I need.
All right, I'll try to do that. Thank you.
We're not getting video. Court calls the case People versus Thomas Vasher.
Actually, line of people.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Vasher.
Your name?
Thomas Vasher.
All right, what are we doing?
Your Honor, we are requesting an adjournment to obtain some media discovery, and when appropriate, my client would like me to address bond.
He has a bond. Hey, do you have the bond violation report?
I do not have the bond violation report.
This just came in.
Oh, then if it just came in, I would not.
A bond violation.
I don't know.
It's a report that was just you.
Oh, you know.
Oh, that's my handwriting.
You know.
Yeah, unless if-
Oh,
I don't.
You didn't remember.
Yeah, that might be why he's in custody.
Right. That
Got it. Okay, got it. All right. Probable cause conference, June 12th, 2025, 9 a.m. As to bond.
as to bond, Your Honor, I'll be requesting a PR bond on behalf of Mr. Vasher for the reason why he missed his last probable cause conference court date. It did appear he was in communication with our office. He did talk to one of my colleagues. They were going to request an adjournment, and he misunderstood, thinking that meant he would, that mean that he didn't have to show up to that particular court date. So we do have good contact information for him. He is being supported by his church and has been attending programming from Home and New Vision. So I would be requesting a PR bond.
You sponsoring the people?
Your Honor, I do believe the defendant is on probation under the 22nd Circuit Court for assaulting, resisting, or obstructing a police officer. In this case, he was taken into custody, I believe, for a warrant related to that probation. And when he was arrested, he was found to be in possession of several different individuals' IDs or cards, or credit cards of this nature. So I do not think a PR bond is appropriate, and he did have a failure to appear.
Anything else?
I said, I was reiterate, I know he has a support system. He will be appearing in the court. We do have good contact information for him, and I will be requesting that.
What do you want to say, Mr. Vash?
Mr. Simpson, Your Honorable Judge, I just want to inform you that every day of my life, I get up and I live with that lady in the back there in the court, and I get on my bicycle and I ride right there, the little lady right there. And I ride my bicycle every day, and I pick up garbage out of churches and school parking lots, and that's where I find
I would advise you to stop making any statements, because those could be used against.
Well, that's just the truth. That's where I even got the credit card.
I would advise you to stop making that statement.
I've done everything right. I'm doing good. I'm really, for the first time in my life, proud of myself.
I've set this out to the 12th. I'm going to deny the request for a change in bond at this juncture. Is he going to be dealing with the circuit court matter anytime soon? Violation?
I'm not sure of his court date off the top of my head. I would have to check.
Okay. So his bond at this point will continue. Thank you.
So PR bond?
Your bond's continued. It's not a PR bond.
It's not a PR bond?
No, your bond's being continued.
I've been doing everything right, Simpson. Everything. Everything I'm supposed to do.
Okay, you keep talking at me, it's going to get worse. Okay, thank you. Court does call the cases of the people versus Quincy Jones.
Hey, Pierre Richard McDuffie for the people.
Cameron Dadish on behalf of Mr. Quincy Jones, who is approaching. Can you put it on the record?
Quincy Jones. All right, he has a new case, you know that.
Yes, Your Honor.
All right. So, Mr. Jones, you have a new case currently, okay? And you're before the court on a complaint that alleges that on or about March 14, 2025, at the location of South Huron in Michigan Avenue in Ypsilanti City, that you did knowingly and intentionally possess less than 25 grams of a mixture containing cocaine. Do you understand that charge? I'm not saying whether or not you did it. I'm saying, do you understand what you were charged, what you're charged with?
Okay,
Do you?
I understand that.
All right. That is a felony punishable by up to 4 years incarceration, $25,000 fine plus court costs. You understand that? Mr. Jones, let me ask you something. If I had you tested right now, you gonna test clean?
For what?
Mr. Allen. Mr. Jones, what's gonna be in your system? Because I can't arraign you if you're under the influence of something. So you might as well just tell me.
Some marijuana.
And what else?
Probably a little bit of cocaine.
Appropriate bit of cocaine. When did you take that?
Be truthful with you.
Huh?
Yeah, I'm be truthful with you.
Okay, so when did you take the cocaine?
About 2 or 3 days ago, so it ain't on my system yet.
Seriously?
Yeah.
So when's the last time you had any marijuana? You're on something.
Yesterday.
You're on something right now. What are you on? What
do you mean? Like,
the worst thing is to lie to me.
what do you mean? What do you mean? Like, on something? Like, what do you mean? Like, did I do something to get today or?
I don't think that's really a hard question.
Oh, I smoked some marijuana last night.
Tell you what, it's real clear to me that you're on something. I'm not going to arraign you on new charges. I'm not going to do anything with these other charges. I'm adjourning all of this over to next week. But right now, on your one case, your bonds revoked, defendants remand.
Thank you, Your Honor. I.
Why?
You can wait till.
Good. That works. And I'm gonna set that for the fifth.
Your Honor? Yeah, I gotta mark it up.
Good job, Denise.
Mr. was asking, has this case recalled because he would like to address the issue of bond?
Who?
Mr. Warren Brown?
Why? What's the issue about?
No, he wants to address an issue of bond.
Client here?
Yes.
He wants me to lock him up?
Probably not.
Can you see him busy?
Mhm.
I'm waiting for the bus people.
Correct.
Where's? Oh, what do you call it? I have Jones and Dalton. But Jones, that was Bukovich running around. Did you find your client?
No, Your Honor. Yes, I checked the restroom.
What,
I
you
did speak.
just leave?
I did speak to my client this morning. I knew he had an appointment to go for begin outpatient treatment today. He told me it was either at 12 p.m. or 2 p.m. He did not remember the exact time. But I did speak to him this morning and get updated contact information from him. So I did try to give him a call and a text, but I haven't got a reply. But he was here this morning.
Oh, thank you for chipping in, Janasa. Everybody was doing just fine. I don't know why did you feel compelled to say anything? Like he told me like 8 times he's been here. Why'd you? Do you know where he is? Then why are you talking? So do you think he's gonna show up or not?
I reached out to him, but I still don't have a reply at this moment. So, but he was, like I said, he was here this morning, so I can try again, but I can't make any guarantees.
So what do you want me to do?
Well, I was going to request adjournment.
Well, that's not happening. I need him here. So what else do you want me to do?
Can you pass the matter?
Sure. That was for dramatic. Yes, I'll pass it.
Thank you, Your Honor.
Court does call the case, People versus Martez Dalton.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Dalton. Please state your name for the record.
Martez Dalton. Thank you, Your Honor, once again for passing up on the matter, sir. I was having a very difficult time getting here today, but I made no excuses. I'm here, Your Honor.
I told you he was gonna be here.
That is not what she said. I had all the faith in the world that you remember. So I'm glad you made it.
And yes, Your Honor. And to be honest, Your Honor, I only need like 2 more weeks to get my license, so this won't even be a problem anymore. I've been working hard as I possibly can to get this license, Your Honor.
Okay. All right. Real good. All right. What are we doing?
We are asking that this matter be set for a preliminary exam.
You have all the discovery.
Correct.
People have their witnesses available on the 10th. Preliminary exam, June 10th, 2025, 9 a.m. in person.
9, sir.
9
9.
That one you can't, that one you cannot be late
I will
to.
not be late. I don't care what's going on. Hell, high water, whatever. I'm gonna be here, Your Honor.
That's what you told me the last time.
I promise. Listen, I broke ass to get here.
Said, I'm gonna get here. I'm gonna do everything.
But last time the D2 A2
Here I
stopped running.
am.
Are you really
Here I am at 1 o'clock
I am
for a
though.
9 o'clock call on your case.
I am getting my license in 2 weeks.
Your Honor, if the court may consider bumping it out a week, or a week after that, if he's gonna have his license, and that way there'll be no issues regarding transportation.
0. Not even trying to play with the court's time, Your Honor. And I appreciate you all for being as patient as you have been. Thank you.
Yeah, that's my middle name. Patience. When are you getting your license?
I have 1 more court date, which is Taylor on next week, Thursday, a week from today. And then I'll paying everything off. I've already paid off quite a bit of money to Warren and Detroit and Canton. You all are coming up in a few days.
So we had to wait behind all those people and wait for you today?
It's just about the court days, the way they was all.
Oh,
Honor, that's all. I can only take care of them when they come up, Your Honor.
Nice try. All right, I'll move it out to the 17th if there's no objection from the people.
No objection, Your Honor.
June 17th, 2025, 9 a.m. That's before.
That'd be before you quit.
Oh, man.
At noon?
Okay, it's at 12 noon.
Yes, sir.
Before me. I dare you to be late.
Oh, no, sir. No, sir.
I double dare you.
Make it 11:30.
So I'll be here at 10 in the lobby.
Thank you, Judge.
Thank you.
Time continued. You're welcome. Court calls the case, People versus Megan Moses.
Ashley Lonnie for the people.
Assistant Public Defender Nicholas Bukovich for Ms. Moses, who should be appearing via Zoom.
Ms. Moses?
Hello?
Hello, I need a camera, please.
Yep, just 1 second. I am indisposed. I gotta wash my hands. Sorry. I got great timing.
We'll wait.
If you,
I'm
yes, Your
sorry.
Honor.
I
Oh,
was not trying
thanks.
to, I knew that would happen too. I'm almost done.
Okay.
Apologies.
Okay. Can you state your name, please?
I'm Megan Moses. I'm coming.
Okay, well, hold on. That's not her. Something popped on, but hers. Okay, there you go. All right.
Hi.
Okay. What are we doing? We're adjourning.
Yes, we'll be adjourning for some further negotiations and some more discussion with my client.
June 17th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Thank you, ma'am. Court does call the case, People versus Jody Ann Russell.
Thank you, Rachel McDuffie for the people.
Student Attorney Andra Sabri on behalf of Jody Ann Russell, who is present in person. Please state your name for the record.
Jody Ann Russell.
Thank you. All right.
Your Honor, we are respectfully requesting an adjournment as a referral has been made to the AIM Division for mitigation and negotiations with the people are ongoing.
No objection to the adjournment. I wanted to ask if we can approach with HD Carrie and Ruby as well to just address some bond concerns that may not be best placed on record.
All right. All right, court's gonna pass this matter and I'll come back and we'll address everything, okay?
Thank you, Your Honor.
Court calls case People versus Renee Schmel. Or Schmel, excuse me. I was putting letters in there. I probably shouldn't have.
Student Attorney Kara Rosengren under supervision of APD Hannah Apple on behalf of Miss Renee Schmel. Can you say your name?
My name is Renee Schmel.
Schmel. Okay, got it.
Yes,
All right. I'll mess it up again, but
I'm sure a lot of people do.
all right. All right, what are we doing?
We're requesting an exam date.
All discoveries complete.
Yes. Yes.
And would people have their witnesses available on the 10th? Preliminary examination in person, June 10th, 2025, 9 a.m. That is before Judge Bar.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you. You know, I walk in and when I see the list of attorneys, what? No, it's not a bad joke. No, it's just my life. I'm going to explain to you something. And I look at the list of attorneys and I think, this is going to be a good day. None of these attorneys are going to cause any problems. They're going to just go out, do their job. Things are going to run smoothly just because of who they are. But inevitably, there's always one or two attorneys that for whatever reason, their day is just going that way. Today's Miss Apple. It's like, for whatever reason, you call your case, your client's first on a bus. He got here. No, we waited. And he was in a suit. He's in a suit, got here. So then I called this other case. And wow, that was a deep breath. And we don't have your client. So what would you like me to do on that? Okay, well, you think about that answer. Ms. Ekenrulli, the case I had you pass, because you're always a problem, so I just have low expectations. Have you had a chance to talk to your client?
I have, Judge.
Huh?
I have, Judge, yes.
You have? You want me to call it or you?
We can call it.
Yes. Court recalls the case of the People versus Jody Ann Russell.
If you were to the group people.
And Assistant Public Defender Chinazi Carey Akinruli on behalf of Miss Jody Ann Russell. Jody, state your
Your
name.
name again?
Jody Ann Russell.
Thank you.
So, Your Honor, thank you for the bench conference. I did have an opportunity to speak with my client. Maybe we should approach Judge, please.
All right.
Thank you.
All right, we're back on the record in the Russell matter. Record truly reflected had 2 bench conferences in this case. I will grant the adjournment in this case. So I'll adjourn. Are you trying to do a whole mediation report with her?
We're gonna need it. Yes, Your Honor.
All right, so I'll go to June 26th. I'll adjourn it to June 26, 2025, 9 a.m. I will have her bond continue in its monetary form and other conditions. I'm going to add 2 conditions to it. And that is that 2 no-goes. So you are not to go to Tonda Elementary School in Canton. You understand that, ma'am?
Yes, sir.
Or to Pioneer Middle School. That's also in Canton.
Yes, sir.
Okay, you understand that?
Yes.
That's all I'm going to do at this point. Otherwise, I will continue.
Thank you, Your Honor.
Thank you. I even talked real slow in that case too, for apples time. So no, here's what I'm gonna do. Here's what I'm gonna do. Because I have faith because of the gentleman that showed up on the bus. Do you have a belief that Benson's gonna be here, or you don't know?
I don't know, Judge. I would love to say I have all the faith, but I'm not allowed to answer my calls or texts.
Okay. Well, why don't we just call it? And I appreciate your candor on that, Ms. Apple. Court does recall the case, People versus Sean Benson.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Vincent. Judge, I did have a chance to speak with Ms. Londy regarding a potential resolution for this case. An offer was extended that Mr. Vincent was entertaining. I had discussed on the break with him. I had a phone call. I don't know what happened to him in his appearance now. He did inform me that he was released from the hospital yesterday and was having some medical issues, which is why he wanted to adjourn to consider the offer and didn't want to make that decision today. But he's no longer responding.
All right. I'll issue a bench warrant for defendant Terry to appear. Bond will be setting him at a 10,000. Cash surety. What I will do, Miss Apple, is I won't issue the warrant until June 2nd. Give it a chance to try to get through him since you talked to him today.
Thank you. I appreciate that.
All right. Thank you. That ends that block. When's my next block?
Your Honor, can I approach on an unrelated matter with
Who?
Mr. Kennedy, myself and Mr.
Oh, I thought I had avoided that successfully, but apparently not.
Sorry.
Okay, come on.
Yeah.
Calls the case, People versus Dijon Williams Watkins.
Good afternoon, Your Honor. Edward Taylor, P571166, appearing on behalf of Dijon Williams Watkins. State your name for the record, please.
John Williams Watkins.
Thank you.
Your Honor, he has a criminal responsibility exam scheduled for June 29th. I just saw the other day, we were still on the docket. I thought they would have notified the court. So we need to get this adjourned to.
Well, criminal responsibility would not be dealt with at this level. You deal with it at the circuit court level.
Really?
So We
Okay,
usually don't await those reports. We deal with the forensic as regards competency, but
well, I got a notice from the court. Okay, so we'll set this for, I guess, exam, yeah.
all right. Discovery is complete.
Yes, bro. You want to see what I got?
Go ahead, go ahead.
Just a second. Okay, yes, you're gonna set an exam date, yeah.
And you have all of the discovery, sir.
I do.
People have their witnesses available to 10.
We'll try our best.
Preliminary examination, June 10th, 2025, 9 a.m. That is before Judge Barr.
Judge who?
Barr.
All right, thank you. All
B-A-R-R.
right, good seeing you.
Good seeing you, sir. Bond.
All right, thank you.
Court does call the case, People versus Elliott Kazan.
Christina, we're gonna get ready for the people.
Wow. How'd you get over there?
What, did they kick you out over there?
No, Your Honor.
So why are you over there?
I'm with Ms. Lundy, Your Honor.
Why is she?
There's a lot of us.
There are. This place is packed with prosecutors.
For the record, Your Honor, Joe Simon, on behalf of Mr. Kazan, state your name, Elliot.
Elliot Kazan.
I'm presuming you have the violation.
Yes, Your Honor. We,
Why don't you
Thank-
approach?
yes, that's what we're going to ask. Thank you.
Apologize, what takes?
Okay.
All right. In this case, we do have a bond violation report, which indicates numerous missed tests. But then makeup tests were negative for alcohol for a late test, with the exception of the 24th, at which point there was a missed test, retested, and showed up with alcohol in the system.
Your Honor, I've discussed these issues with Mr. Kazan. He's going to admit to the court to consuming alcohol. I don't know if it was the 23rd segue into the 24th, but whichever that day, in violation of his bond, he's going to not try to deny it. He's going to claim full responsibility. We have some requests as a result of that, but first, I think that he's ready to address his.
And that's correct, sir. You admit to this violation?
Yes, Your Honor.
I will not take his plea today. I will adjourn the probable cause conference out to June 5th, 2025 at 9 a.m. And what did you want to say before I sent him?
Your Honor, my client has been screened and assessed with Matthew Statman. That's the provider that the remand court uses. He has made arrangements for his recommended outpatient treatment. It took a while due to backlog, but he's pushed it up and he's got, if the court would permit him, 9 a.m. tomorrow at UMATS, which is the University of Michigan Alcohol Treatment Services or something like that, or I can't remember the full acronym. Anyway, at 9 a.m. is his intake. Additionally, I told him that continued SoberLink testing is not recommended for him, that even though it's summertime, scrams can be uncomfortable, particularly when we stop wearing long pants necessarily, et cetera. That would be the only thing that the court might entertain in terms of making sure he's not a risk to others or a danger to himself. He said he would happily do that immediately, turn in his SoberLink and put on a scram and wear that. So that is our request, Your Honor. I told my client that the court in this situation typically revokes somebody's freedom, revokes their bond and incarcerate them. He's prepared for that eventuality, but hopes the court will consider our request, our alternative request.
The court looking at it, and we had a bench conference about this, I think, when I looked through and there's a missed test. I also am concerned with the fact of the blood alcohol level at a 10 o'clock a.m. testing, which tells me that there's probably a whole lot more going on because he had previously missed the other, or had missed the testing at 7 a.m. So when I look at it all, that seems to me to be a big problem in terms of a gap, and I think there was a lot more alcohol consumed than what this one PBT indicates. At this time, given that the defendant has admitted to the violations and violated his bond, the court is going to revoke the defendant's bond. Defendant's remanded to the Washington County Jail. So we'll see you next. Court does call the case of the People versus Stephen Johnston.
Okay, Richard McDuffie for the people.
And Allison on behalf of the people, Your Honor.
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Johnston.
All right, I put this over to this afternoon. What have we determined?
Yes.
Good evening. Well, good afternoon, brother.
Yes.
All right.
First, I know Mr. Johnson was able to speak to one of my colleagues when I was in court this morning. We will be, I know we have a green sheet in there. He will be waiving his PE for this to go over to circuit court. I will have him fill out that form momentarily, Your Honor.
So he's waiving up?
Yes, he'll be waiving up.
All right. Is there any issue I need to do with bond on this then?
Your Honor, at this time, we would be asking for a no contact order to be put in place.
I thought you did give the change this morning.
Kristen Kinduski, Your Honor.
Okay, help me. Name.
Can we approach, Your Honor?
Yes. Counsel. Go ahead.
Yes. So in addressing the prosecution's request for no contact, Abby is saying per his probation cases, he does have a consensual contact order with the complaining witness in those cases. She did make a 40-minute victim's impact statement confirming that she did want contact. I can confirm this with his APD who represented him at the circuit court level. Judge Conkey there made a determination that contact would be proper if it was consensual contact. Similarly, this was a request that was made at arraignment on this case. I was not myself who handled it, my colleague. However, Magistrate Otella there also made a determination based upon the allegations related to this case, which is two R&Os and alleged two R&Os and a possession that that no contact order was needed. The alleged complaining witnesses in this case before you at this moment would be the police officers, not the complaining witness from his past cases. So I'll be asking for no modification in his bond.
But you would agree that between the time of the arraignment, well, between the time of Judge Conkey's hearing, the time of arraignment on this case, that certain circumstances have changed regarding that contact. Meaning phone calls that were made, which one could look at as interfering or otherwise attempting to try to obstruct this proceeding.
While context may be changed, he has indicated that prior to this, he was never near her. I understand the concerns that you're addressing with these phone calls. However, again, they are still not a violation of his previous probation. So
right, okay, so that we're not getting, so that we're clear in what I'm saying. I'm not saying that they're necessarily a violation because the no contact does not exist. I guess I'll put it that way. I mean, it's permitted contact. But once that contact then begins to happen, the subject matter of that particular contact, what's said, could change those circumstances, I guess, in terms of whether or not contact should continue to be permitted. I mean, if somebody calls and is making either threats or some other type of statement to someone, that could lead the court to then change the bond conditions on the case. You would agree with that, would you not, Mr. Buckovich?
yes, I understand what you're saying here.
All right. Okay. Anything else regarding this case? I'll take the waiver in a moment. You're gonna wait. He's waiving up.
Yeah, we get you in front of Kunke.
You know what, Your Honor, I might as well just wave up to Conky.
Okay.
Okay, if that's what you wish to do. Sir, you,
Tells me addressing bond, I'm not changing when it was in no contact with her. That's what I was addressing. I'm not gonna be right towards you.
Just one more time to reiterate for the purpose of bond. Those calls can also not be interpreted in a way that is non-threatening, so I would still be asking for a.
you're saying they could be interpreted as a way of non-threatening?
Yes. So I would still be reiterating that I would be asking for no modification in bond and no contact order to be put in place.
Is there anything from the people on that?
There is, Your Honor. So first of all, I want to point out that at the arraignment with Magistrate Otisella, Mr. Bukovich and I were both present. As he mentioned, it was his colleague that handled the arraignment. There was not an extended back and forth about the no contact provision. We made the request, it was articulated on a recommendation form, and the magistrate declined to order it. But there was no, honestly, it could be that it just slipped his mind in terms of that being a request, and I maybe should have done a better job of reminding him about it. But I want to point out there was not an explicit denial of that request on a basis of it not being necessary. Second, I understand that this was prior to sentencing. In the GBH case that Mr. Johnson had with this same victim, I understand she's not a victim in this case, he previously had an issue where his wrong privileges were revoked first. Then there was a motion for forfeiture by wrongdoing. It ended up not being necessary because the case was bound over at exam. He continued to contact her after that, discussing the fact that she did not want to cooperate with the exam from different people's pens. So it's an ongoing problem and it's an ongoing pattern with this case. He made some comments at the arraignment on this case that quite frankly raised a red flag for me with the concern that we were going to end up right here like we are today. The people are requesting a simple no contact. It's unclear to me. I understand that consensual contact was granted by the circuit court. That was in January of this year when he was sentenced on that GBH case and on the possession of methamphetamine case as well. He is charged today on this case with another methamphetamine case and are now emanating from this victim, articulating concerns about her safety with him. We think that the circumstances have clearly, if they were deemed to be appropriate back in January, have certainly changed by now. So the people are, again, requesting a simple, but straightforward, no contact whatsoever with this complaining witness in this case. Given the history here and the fact that we have a pattern established of a failure to abide by bond conditions beyond the revocation of previous phone privileges.
Wow. All right, here's what the court's gonna do. Well, is he waving up or what's he gonna do?
He's waving Kunke.
Or did you wish for the adjournment, Mr. Frank?
Your Honor, I'm quite confused on a couple of things, if I'm able to speak to you for a second. The complaining witness of who they are talking about, I understand my attorney's sitting right here and he's present in front of me. I'm speaking on my behalf. She went in front of Kunke, Judge Kunke, and admitted to her full honest truth that I did not assault her, harm her in any condition or form, okay? And also even stated that drugs were planted inside of a book bag, Your Honor. Was planted inside of a book bag. This is on transcript in Kunke's courtroom, Your Honor. And by me not being able to have contact with her is, I'm confused on it. I'm not being explained or talked to the reason why I cannot have conversations with my fiance and soon-to-be wife. When this drug charge had nothing to deal with her, it had to deal with a
But you making statements to her that the reason behind your predicament, and I'm paraphrasing this and putting it, is because of what she did are problematic.
What she did?
Because that you're in the circumstance you're in because of her. Those are problematic comments.
Okay, so that's the reason why I'm not able to have contact with her. She didn't put me in this predicament. Her doctor
Sir, I
did a
advise you stop
welfare
making
check on her.
statements. I advise you stop making statements, because this is related to this case at hand.
And can you speak for me?
Sure, I've explained that. So statements can be used against
Do
you.
you wish for me to adjourn this rather than to
No,
do the
give me
waiver?
the pen. I'll go in front. I'll go in front of council, man. Have yourself a good day.
Really hope he didn't run or act that way. So you signed this waiver preliminary examination?
Correct, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah, I do, Your Honor, even though there wasn't one committed, but yes, I have to.
I'm
get
not
it.
taking his waiver. I'm just gonna adjourn this out. You can talk to your client. He can figure out what he wants to do. I'm asking very simple questions. He seems to get angry at me. I don't even know why. I'm making the findings based upon what's presented to me. But if he's gonna act this way, I'm just not having it. So,
Would you like to briefly pass this matter so I can speak to my
no,
client? Your
I'm
Honor?
not gonna pass it. I'm gonna adjourn
not
this
mad.
to another
Oh,
day.
I'm not mad.
I'm
I'm
going
not
to
upset.
adjourn this to give him 1 week out. We'll go June 5th, 2025, 9 a.m.
Mr.
or as his
Simpson.
invite indicates. I am at this time going to change the bond conditions. I'm going to leave his bond in its monetary amount as it's set. I am going to order that his phone privileges at this juncture are revoked. You could bring that up again at the next hearing. I'm also going to indicate that there's no contact with Christian Kanuski. I'm going to order that at this point, and then he can decide what he wants to do with the case. But if he thinks I'm going to put up with his behavior, I'm not doing it. I'm
Your
done.
Honor,
Thank you.
I'm not upset, Your Honor. I said just. Okay. Not even upset at all.
Does call the case of the people of the state of Michigan versus Jerome Burns.
Good afternoon, I'm Marie House, Assistant State Attorney on behalf of the people.
And Assistant Public Defender, Chinazi Kyriaki, Your Honor, on behalf of Mr. Jerome Burns. Mr. Burns, would you state your name for the record, please?
Jerome Burns.
Your motion.
Can we? Sure. Hey, but Judge.
People have been approaching all day. Come on.
Thank you for that, Your Honor. Your Honor, obviously, we're here today. The people filed a motion for a bond violation revocation.
Yes.
It was an emergency bond motion, Judge. I have had an opportunity to review the details of the motion as well as the supplemental report that was accompanying it with my client. My client would like to enter a plea to the violation of his bond in this matter. It would be a no contest plea. We are satisfied with the court using the information, the supplemental report as the basis for that.
You understand that, Mr. Burns?
Yes, sir.
You understand that I will accept the facts that are contained in here as true.
Yes.
And you do not wish to have a full-blown hearing on this, sir?
Do you wish to have a hearing on this?
Is it what we just talked about?
A hearing is where we have testimony. Somebody comes out and says.
Yeah. And then,
You don't wish to have a hearing, is that correct? If you don't have a hearing, that means you're pleading guilty to it.
I'm going to do. Yeah, yes, Your Honor.
Yes, sir.
I'm not going to do the hearing.
You do not want the hearing on this. All right.
Your Honor, if I may, before he enters his plea, we discussed at the bench and I informed counsel this morning, there's also an additional statement. We want to make sure that's part of the record.
Yes.
I missed it in the written motion that it is on the jail call provided. Defendant made a statement that if he is released from custody, that he would take the child that he shares in common with the victim away from her and leave, and the victim would never see that child again.
And Your Honor, I just, again, we're not disputing any of the information that's been provided, Your Honor. I think that it is important that we, for the sake of the record, clarify the intentions behind that particular statement. It was made. We're not disputing whether or not it was made. There is a difference in parenting. He does not, parenting styles, I would rather say. He has spoken to me previously about his views on parenting style and how they differ between he and his wife. He tells me that that particular statement was because he felt that the child would be better with him if that were to happen. If obviously they would have to go through family court and fight that matter out. He never intended on kidnapping or stealing or doing anything illegal as it pertains to his child. He has told me time and time again, he sheds many tears when it comes to his child and his child's health issues and what they have been through as a whole, as a family, dealing with his child's health issues, Judge. So that does not change our position today.
Can I just say, I'll let you go on, counsel, but I'm having a problem with that.
Okay.
Because I've listened to his phone conversations provided to the court in preparation for this hearing. I look at the words that he uses, and that sentiment does not by any means fit with anything that he has said at all.
I completely understand that, Judge. I know that when it comes to when we're given the opportunity to elocute on his behalf, Your Honor, there is some information he'd like for us to provide to the court. I don't know how helpful that is going to be, but I completely understand the court's position.
Your Honor, after that question, I'd like a chance to respond if I may.
Well, here's what I'm going to do. I'm going to to the bond violations regarding the contact, attempted interference in the case, comments regarding the court, also attempts to interfere with the orders of the court, and the statements being made and attempts to make direct or indirect contact with the victim in this case. How do you plead to those?
No contest.
No contest.
What I wasn't going to sentence him at this point in time. He is set for PCC next week in any event. So I was going to move any sentencing or anything that the court's going to do at that time, hear any statements that counsel wants to make, as well as any additional information from the people at that point, if it worked for everybody.
That's fine with us, Your Honor.
That's 6/5, right? So the probable cause conference, which has already been set for 6/5/2025 at 9, continue to that day, and the sentencing on bond violations will be set at that time. All right.
Thank you very much.
At this time in the interim, however, what I am going to do is
Next week.
I am going to, given what the court has heard thus far, I am going to revoke the defendant's phone privileges at this time, however. Thank you. Bond will continue in all other aspects. Court does call the cases of Sycamore Meadows versus, well, let's do it this way. Jimerson, LaFleur, Hatch, Phelps, McCoy, Rawls, Story, and Brown. You guys should stay right there because we're gonna do. All right.
Good afternoon, Your Honor. Jill Bauer. I'll fill in here for everyone.
All right. And that's on behalf of everybody but Mr. LaFleur, but I don't have him. Is he here? Oh, you can come on out because you're not represented by legal services. Is that correct?
Yeah. Yes.
Okay, come on up. Well, no, Miss Jemerson, that's going to be taken care of.
Yeah, Ms. Jimerson, we're going to enter an appearance today.
Right. So you don't want to be represented by.
I do. I wasn't just. It's been going on. Well, I have an application already, so I figured I didn't.
Let's do it this way. why don't you talk to them, have them represent you, because there were conversations in there. Your case is actually very simple in a lot of ways, so you can make the decision. I think we can have it resolved. On all of these cases, there's been an in-chambers conference. I think we are close to being able to resolve all of them. There's certain work that needs to be done. That can be done within the next 2 weeks. And it requires, in most of the cases, some communication from legal services on behalf of the tenants to the landlord, and then their action from there. So what I'm going to do with all of those cases, I will adjourn them to the 13th at 12 noon. In-person hearings. Okay.
Okay.
So talk to legal services. They'll explain that.
All right.
You really want me here on a Friday the 13th?
That is my lucky day. So no, I'm kidding. All right. Yes, ma'am. Your name?
Jessica Brown. Sorry, Your Honor. I have a student graduating next Friday, and then another student moving up to go to high school on the 13th. So my schedule.
So what?
June is hard.
Your students?
They're my person. I say students because I also am a teacher, but they're also my children.
Oh, they're your children?
Yeah, so my son is graduating this upcoming Friday, and then my daughter's going to high school. Sorry, I'm emotional because this is a lot, but on the 13th, and they have a half day.
So hold it. You're coming before me with all of this good news for your family, and you want me to make some kind of exception.
I just might be a little late
because you want to be at your child's graduation. Miss Brown, let me tell you something. If you show up here and are not at your child's graduation, I will lock you up. All right. I'm gonna let you know.
I believe you.
You don't need to be here with you.
Thank you.
You worked hard, so those babies are doing what they're doing, right?
They are.
So that's where you need to be.
And Ms. Brown, Legal Services is officially representing you, so we can handle your case whether you're here or not.
Okay, thank you so
And
much.
so you just enjoy, and Mom, I'll just tell you congratulations.
Thank
to
you so much.
Okay.
Thank you.
You take care, and you just have a great time, and tell your kids that Judge Simpson says congratulations.
I definitely will. Thank you
All
so
right.
much.
You take care.
Thank you, Your Honor.
Thank you. I don't even know why that was a debate.
Thank you. Thank you.
Bishop Pickering versus Andrew Rich.
Good morning, Your Honor. David Fanter on behalf of Bishop Pickering.
And your name, sir?
Andrew Rich.
Good afternoon.
Your Honor, Mr. Rich pays his rent with his disability check, which he receives on about the 25th or 26th.
Got it.
Which until last week I wasn't aware of, because he had, for the most part, done a pretty good job of paying
forward
ahead of time. So now I'm aware. What I explained, and what he did was he got his money order and he mailed it to Lansing. I told him from now on, drop it off at the owner's house at 206 North Huron, so it'll be on the account more quickly. And so we haven't received that yet. So what I would like to do, this is my one case, I'm going to ask for an adjournment for 1 week. When we get that money, I'm going to dismiss this case.
Got it.
And I've got Mr. Rich's phone number, so I'll be able to communicate with him going forward.
Mr. Rich, is all of that correct?
Yes, so it's correct.
That's correct.
I just get out of dialysis, so if I'm kind of acting down.
Pardon?
I just got out of dialysis.
Okay.
I'll be feeling funny when I
Got out.
get out of there.
Okay. So what I'll do is I'll adjourn this to June 6th at 1 o'clock. Okay. But you may not need to be here if your check gets there. Okay.
Okay, 1 o'clock.
1 o'clock.
But hopefully you won't be able to, you won't have to come.
I'll
talk to you Monday or Tuesday.
I mailed it. I like I was telling him, I do the same thing every month. I go get my disability check cash, and I go pay my telephone bill. Then I get on a bus 6, which takes me out to Xfinity to pay my TV bill. But out there, it's a mailbox there. So I usually take my money order and just stick it in the mailbox and go across the street
to Xfinity and then I paid all my bills, I'll be broke, but at least all my bills.
When
are
everything's paid, right?
So that's how I've been doing it, and I'll get my money on the 25th and 26th every month, some like twice or three times a year. It come on the 27th, you know, but I've been doing it that way, so he will get the money.
Okay, everybody believes you. We're just doing this to make sure it gets there.
Yeah, I can't dismiss it till I got it, but I'm sure we'll get it early next week.
You'll get it, I mailed it. You know, so.
All right. Okay, you take care, sir. Have a great weekend.
Okay, and thank you so very much.
You're welcome.
Thank you, Mr. Richard.
God bless.
Thanks. That's all for me today, Your Honor. Have a great weekend.
You do the same. All right. We're to stand in recess.
All rise. Ladies and gentlemen, that's all I got. I hope that's enough. That was a lot. Put a whole lot of stuff together. We've been here for a long time, y'all. Almost 2.5 hours. Most of it was Judge Simpson. Most of it. But we've been around the country this morning. And I'm telling you, that's not even all of the good cases. I know for a fact I had to trim some down. I mean, we'd be here till 5 o'clock tonight if I did. So, be looking for some more court videos to be released. Got a lot more to get out there. I wasn't able to cover here today. But ladies and gentlemen, thank you for coming and hanging out with me. I am your Lone Wolf Usul. I am your host for the Weekend Review, and I am your curator for the Court Gallery. Come by and hang out with me. I do a premiere every single night of the week where we watch an hour and a half to 2 hours worth of the daily dockets and stuff that I grab that doesn't necessarily work as individual cutouts, and it works better together. We all get together and we watch these dockets and we talk about them. Come by and hang out with us. A lot of fun. All of the usual suspects from the chat are usually there. Rhonda, Eileen, Mama. All the mamas are there. Patrick, Lemon. Thank you all for showing up today. I can't name everybody in the chat. Everybody's great. Chat's been awesome today. I am going to take some of these videos we watched today and I'm going to snip them out into their own little standalone videos so that people who weren't here today might be more interested in watching it in a non-2 hour format. A lot of people enjoy it that way. So, hey, that's what we're going to do. And I'm going to say good day. And I'm going to see if Mama Wolf needs anything done. And I'm going to get the puppies taken care of. And we're going to move on and check out some more court when court's available. Court's always available. Ladies and gentlemen, thank you for coming out. It's been a great Saturday. Come by and see me every weekday, 8 p.m. Central Time, 9 p.m. Eastern Time. And I'll check you guys out next time. I'm Lone Wolf Usul, and I'm out of here. Have a great day.